So I've been to several sessions over the last 2 days, and what I know from those and from working with a lot of marketers every day is that you all love metrics. You all love numbers. It's how everything gets measured in your world. So we thought we'd start out by sharing a few numbers that are fairly fresh in the content marketing space. There's research that came out 2 months ago and 1 month ago, respectively, from She Speaks, which is an influencer marketing firm, who polled about 400 to 500 influencers and asked them about their practices with respect to legal compliance and disclosure. Some of the numbers are great. Some of the numbers are downright disappointing, and a couple of them are scary, and I wanted to just share them with you to set the context of what we hope you'll come away with today, which is some helpful tips about being on the right side of the numbers. 54% of influencers report increase in receiving requests for sponsored content in the past year. So if you are in the business of creating sponsored content, that's great news for you, and hopefully that's led to a lot of opportunity for many of you. 95 is a good number in this case. 95% of influencers say that they disclose their brand relationships, which means that when they are posting on social as an influencer, when they're creating content to support the goals of a brand, they're disclosing their relationships properly. That's a great statistic. This one starts to get a little more scary from the perspective of an advertising lawyer. 91% of influencers say they've actually been asked by the brand to make the disclosure. That number should be 100, and we'll talk about how to get closer to 100 later on. But 91%, still not a terrible number, but there's probably some over-reporting here on the influencer's part, in my opinion. All right, this number starts to get a little bit more disappointing from my point of view. More than 30% of the native ads that are placed, according to Polar, which is a publishing and influencer marketing native advertising tool, say that the native ads they place do not comply with FTC disclosure requirements. More than 30%. And this is from a company that is in the business of the back end of placing and creating native advertising. That's a bad number with legal consequences for many of you. This number was the most surprising to me, got a lot of press in Ad Age, Ad Week. 25% of influencers have been asked by a brand affirmatively not to disclose their relationship with the brand. It's illegal. It can be very costly, and it can definitely damage your relationship if you're on the agency side with your brand, and it's certainly going to create uncomfortable conversations between the brand and regulators. Advertising is still a highly self-regulated industry, believe it or not, which means we're pretty much permitted quite a bit of latitude in policing ourselves for now. But the FTC is really increasing its compliance work. So these numbers I'd love for you to take away as sort of a context for why we're hopeful you brought a lot of great questions today and why we're hopeful we can share a lot of information with you about being on the right side of them. So Ruth's going to tell you a story next about another big number, and that number is 50. So Ruth, over to you.
All right, so there's a brand called Lord & Taylor, and they have a clothing line, and they wanted to make a splash when they launched their latest line. So they reached out to 50 Instagrammers who have a strong following with fashion, and they said, we want to pay you to take a picture of yourself wearing our dress, and we want you all to post it on the same day. They called it a product bomb. Each of these influencers was paid between $1,000 and $4,000 each. The company had to see their post in advance to make sure that they had all the proper hashtags on it and all the proper labeling so that they could have the most impact. And they partnered with Nylon Online Fashion Magazine to run a native ad on the same day as well so that they could have the most impact possible. So And all these things the company had to review and approve, and even for some of them tweaked it before the day where all these posts went live. On none of them, 0, did they disclose the relationship between Lord & Taylor and Nylon Magazine and Lord & Taylor and all these social influencers. That's a violation of FTC violation. And it just, I don't know about Sharon, but this blows my mind that they made such a huge mistake. All they had to do to avoid making this disastrous problem is put just a little hashtag ad on that, and it would have resolved their issue.
Right.
The FTC had come out with guidelines, thankfully for them, after this happened, because the FTC can fine you $16,000 per violation. Now, these guys were lucky when they were investigated that they grouped them all in, like, all 50 Instagrammers were one violation. I looked at that and went, why didn't they call that 50? Then plus Nylon Magazine. And I was surprised that nobody thought to ask anywhere in this story, don't we have to disclose this relationship? None of the Instagrammers, not Lord & Taylor, and not Nylon Magazine. So that tells me that there are a lot of people out there who are really excited about partnering with social influencers and social influencers who are partnering with other brands who are setting themselves up for a lot of headaches. Lord & Taylor got lucky and they just got a slap on the wrist and they're just being monitored by the FTC, but this could have been a very costly mistake for everybody involved.
Well, they got the dress for free too, by the way, which I mention only because even if these influencer bloggers had only received the dress and no monetary compensation, they would have been required to disclose that relationship. Additionally, what's important about this case, beyond the sheer naivete, perhaps, shown on the part of every single influential blogger who was used in the campaign, and these ladies, and I say ladies because they were all women, know their way around the rules because this is what they do for a living, and so should Lord & Taylor and whatever agency was involved in helping them execute the campaign. But it was a beautiful and exciting campaign executed illegally, unfortunately. And what's significant about it for all of you as brands or agencies who work with brands is that this is really the first turn of tide in terms of the FTC stepping up its regulatory efforts with brands and making sure you're all being compliant on social and in content. This is an example of social media and content marketing, because this Nylon article was actually a native ad, which was not framed as a native ad or accompanied with a legend indicated that it had been paid and placed content. So there's lots to learn from this example, and lessons in not only native compliance, because there are new FTC regulations around native advertising, which you should all be familiar with and fluent in, as well as social media and testimonial disclosure rules. So with that, we're going to open it up to questions. There are lots of issues that are invoked in content marketing and social media compliance, not only regulatory, but intellectual property use. And we are here to answer whatever you throw at us, or at least do our best to do so.
Right. So between the two of us, we can answer questions about contracts, copyright, trademark, website terms of service, working with third-party content creators, influencer marketing, privacy, defamation, anything in that realm we can answer. But before we jump into your first question, Jordan is going to be our man on the street. We have to give the standard disclaimer because we're lawyers. We are lawyers. However, when we are standing on this stage, we are not your lawyer. We're here today to provide general legal information. This is not a substitute for legal advice. If you need legal advice, go hire somebody.
Everybody gets that, right? Raise your hand if you
understand. All right, we all got that?
All right, good, cool.
And will someone please tweet a picture of me? I never wear dresses, so this needs to be documented. All right, who has questions?
Maybe right here. And then I see you later.
I'm not going to do Jordan's job.
All right, here you go. have a question regarding online reviews when it comes to attorney marketing and healthcare marketing. I know there are certain disclaimers and confidentiality and things that you have to watch out for.
Okay.
What would you say are kind of your best practices of things to keep in mind when it comes to that?
Consumer reviews of attorneys or healthcare?
Yeah, when it comes to, or I'm sorry, not online reviews. I meant social media. But
Okay.
it could come into the online reviews realm as well.
There's always, I'm just going to give an introductory and then kick it over to Ruth. There's the FTC's rules about social apply across all industries. But in addition, if you are working in a highly regulated industry like healthcare, financial services, legal, there are a few others, you have your own industry peculiar regulations to also be aware of. In the case of lawyers, we are ethically bound to not be able to do certain things. And that varies state by state because lawyers are still governed by their state bars. There's no federal standards for the most part about what we can and cannot say and do. So not only I can't think of a legal situation where the requirements of disclosing compensation would come into place, but it could be for testimonials, client testimonials, but we certainly have to disclose, just like any other industry, when there's an ad, when it's a placed piece of content, et cetera. Same for healthcare. But on top of those things, you've got to worry about, in the case of healthcare, HIPAA, and making sure you're not breaching any privacy rules, as well as all the ethical restrictions that obligate all the bars in every single state for lawyers.
Yeah, I know in my state, whenever like a past client does a testimonial on like a TV commercial, they have to have like there's the little print that says actual client versus actor portrayal. Mm-hmm. And then I know on the flip side, when we are speaking as someone who's a member of a regulated industry, we have to always include the disclaimers. So I always tell lawyers always have like the sidebar that says the disclaimer. Coming to my website does not create an attorney-client relationship with any reader, and similar disclaimers apply in the medical field. The one I refer to for people who are in medical is actually Dr. Drew. If you listen to his podcast, there's always a disclaimer at the end that's actually really, really well written.
And so any content we publish as well needs to be framed with that disclaimer so that it's not construed as individual or one-on-one advice. And we had a question back there, lady in the orange. Oh, sorry. We'll get to you.
I actually have two questions, if you don't mind, but I think they're of general interest. So in order to disclose a paid relationship, is using the hashtag ad sufficient? And the other question I have is, what is the status of being a brand being able to copyright a hashtag, and where do you think that will be heading?
So I can answer the first one quickly. Ad is almost always sufficient.
For now.
Okay. Yeah, true.
A good place to keep an eye on is ftc.gov. Yeah. They write the rules. So currently they're saying hashtag ad is sufficient for like Instagram, Twitter, Facebook, all that.
Right. And
can you copyright a hashtag?
So let me back up a step and distinguish between copyright and trademark. A trademark is the moniker that identifies the source of some good or product or service. So you may or may not mean trademark of a hashtag. I think you do. This is a trend. This is an emerging area of the law, and unless you've got some secondary meaning, which means that you can claim some sort of ownership position in the word, the phrase, whatever, as an actual trademark, it's not very likely that you're going to be able to claim it as a hashtagged trademark.
And to piggyback on that, to register a trademark, minimum, the fastest I've ever gotten a trademark application through the U.S. Patent and Trademark Office, 8 months. Yeah. Is your brand still going to want that trademark or care about it 8 months from now? So you have to look at like the whole perspective.